So, Renato, will Trump face all the charges in the superseding indictment?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet.
So, yay, we have some news on the Trump cases.
It's been a while, right?
Yeah, it was kind of a slow few weeks, and we were kind of like, what do we talk about? I mean, there's a lot to talk about, but we know that our listeners are most interested in these particular cases. And this week we have a ton.
Yes, Pancake agrees.
Pancake does agree.
He just paid us a visit. Yeah, so look, there is definitely some big news this week. And let's just start with what I think is the most important thing. There's now a superseding indictment, which helps us understand why Jack Smith needed more time. He was impaneling another grand jury, getting the evidence before that grand jury so that this way they could return the superseding indictment. And just for our listeners' benefit, a superseding indictment is essentially an indictment that will replace a prior indictment. It's often used by prosecutors to add additional charges. Let's say they continue their investigation, they discover evidence of another crime, they want to add it. But in this case, I think, Asha, it was meant to clean up the indictment after that, I'd say, very problematic, controversial Supreme Court decision, which really cut out some of the crimes that Jack Smith had brought, particularly the crimes relating to the abuse of the Justice Department using Jeffrey Clark.
Right. This is trying to excise anything that would be an official act, either as chargeable conduct or for its evidentiary value. Sorry, Pancake. He knows as soon as I start doing the podcast or I'm on any kind of Zoom, he's there.
That's great. This is what you miss out on if you don't watch the YouTube version. You miss out on Pancake kind of going right in front of Asha. Like as Asha's talking, there's this majestic cat that kind of slowly comes right in front of your face, which I think is amazing. It really improves the quality of the analysis.
It does. But before we get to the reasoning, can you talk a little bit about what was Jack Smith insulating against by bringing this in front of a new grand jury? Is it the idea that to the extent that none of the excised conduct or the excised statements or things, et cetera, to the extent that it was either charged or used as evidence, if he went back to the same grand jury, there could be an argument that they were somehow tainted because they had already heard all of this before. So you couldn't be sure whether they were indicting based on the streamlined one or not. And so he's just like, let's just be done with that argument. And I'm just going to impanel a new grand jury.
So I think part of it may be, Asha, I don't even know if the prior grand jury still exists. In other words, grand juries sit for periods of time. Often, I think, I think a special grand jury usually sits for 14 months. So they may not even still be sitting. They may have already been dismissed. And I think the real question for Jack Smith was, do you proceed with the original indictment and just try to cut off pieces of it and say, look, let's just eliminate these paragraphs and we're good to go? I think what Jack Smith wanted to avoid were questions about how we're going to slice and dice this indictment and what's going to be excised. That would take a lot of time. There'd be some back and forth with the defendant. So I think this was his way of coming out and saying, here you go. I've made the decision for you. This is what I believe comports with the Supreme Court's decision. Now, the defense is not going to agree. And, one thing that a lot of our viewers and listeners are going to remember when we talked about the Supreme Court decision is that while there were certain pieces of it that they were crystal clear, that the Supreme Court was crystal clear, are official acts. In other words, even and it's hard for me to believe this, using the Justice Department to send false statements to try to influence the populace into believing an investigation is exists that doesn't exist. But that was definitely an official act. But there are other pieces that the Supreme Court basically said it depends on the facts and circumstances. So I still expect there to be a fight about certain pieces of this being an official act.
Indeed, because he is taking a gamble with some of the stuff that is debatable. I mean, the Supreme Court's decision isn't exactly crystal clear. It's very clear that some of the stuff is going to be litigated, but maybe we should go through, if you kind of do the side by side on what we don't have to go through it side by side, line by line. But the point is, like, when you do look at it side by side and see what was cut, what was added, you start to see what the strategy was that he was engaging in.
Yeah, I actually think, Asha, this was my initial reaction, at least, and I'd be interested if you disagreed. I think he tried to be as minimalist as possible. In other words, he did not take the approach of striking the maximum amount of material that he could have. I think he tried to only get rid of material that, after the Supreme Court decision, was obviously going to be viewed as an official act. So it was mostly just the Justice Department piece that I mentioned earlier, which is where essentially Jeffrey Clark wanted to send out a letter on DOJ letterhead saying, "Hey, we've got a fraud investigation," and calls into question the results, which, by the way, was a false statement.
Yes.
Yeah,
and he takes out anything where not just with Jeffrey Clark, but any conversations with anybody in DOJ. So there's huge swaths of that whole little sub conspiracy that are taken out. But I basically saw three big themes, and you tell me if this is what you saw too. The first is a lot of additions and clarifications when looking at what Trump was doing, to emphasize that in every instance he was acting in his private capacity as a candidate for president. Emphasizing, that's how he was bringing his lawsuits that were, there to cast doubt. That's the capacity in which he was talking to all these, co-conspirators about the false elector scheme, even with the tweets. And you remember in the Supreme Court decision, they left open the door that tweets might be official acts. And Jack Smith says, well, Trump's use of his Twitter account was sometimes to, in his capacity as president, but also sometimes, just for his own, private expression, and talking about himself as a candidate. And so those tweets that he issued, especially after the mob attacked the Capitol, he kept in there as, to show all of the things that happen as a result of Trump's actions. The second thing is that, as you noted, he excised all of the things regarding DOJ, but again, emphasized that with the other kind of co-conspirators, he emphasizes that they were all acting in their private capacity. So,
right. And including when he discusses Pence, I thought very importantly.
That was my third one.
Oh, well, then I want, okay. Let's go to your third one. I don't mean to, I shouldn't interrupt.
Oh, that's okay. No, I was just going to say the third one was, yes. Then when he gets to the vice president, he emphasizes that in all of the instances where Trump is speaking to Pence, he is speaking to Pence in Pence's capacity as the president of the Senate. And I thought this was really clever. And we can unpack it a little bit more, because Pence's role as the president of the Senate is essentially a legislative role. That part of his job is actually under Article 1 of the Constitution. It doesn't come from Article 2. And so what I think Jack is going to argue here, to the extent that gets litigated, and that it will, is this cannot possibly be an official act under the executive power, because Pence is acting really in the service of another branch, and Trump is acting in his private capacity as a candidate. There's nothing here that falls under even the outer perimeter of executive duties.
Yeah, very smart. I agree. 100%. I agree with your analysis on that. I thought that was the most interesting. I was going to raise that as myself. I thought the having Pence be in his role as president of the Senate was important. I also just wanted to circle back to your original point about a superseding indictment, Asha. This is yet an even more important reason why Jack Smith was using that tool that was available to him. Because if you just took the existing indictment and just took a Sharpie to it and X out certain paragraphs, you can't add words that the jury didn't find. So this way, he basically put it all in there. He gets to put his own gloss on it. Now, does that gloss control? And that's an interesting question here. So typically at this stage, at an indictment stage, the judge has to presume that the facts in the indictment are true, which often makes it so defense attorneys, you're kind of raising your fist and you're frustrated because there's something there's no evidence of, the government just threw it in there, and you have to accept, the judge has to accept it as true and will keep it in through trial. But here, I believe that that Judge Shutkin will have to consider underlying evidence and extrinsic evidence. In addition, I think the Supreme Court, my recollection of the Supreme Court opinion was that she couldn't just rely on the words of the indictment. But nonetheless, the language in the indictment is going to be really important, and it's going to show what his contention is and what his burden is, because he's going to have a burden of showing that, for example, Trump was acting in his private capacity.
I'm not sure I'm totally following that. She has to consider.
I think that when she considers whether something is an official act or not.
Yeah.
I don't think that the language of the indictment ends the question.
In
other words, I don't think Jack Smith can just say, "Yep, Pence was acting as legislative capacity," and that ends the inquiry. I think Trump's team is going to say, "You need to look beyond the text of this." I think that's what the Supreme Court was indicating. Like, she's got to at least look at what evidence there might be, whether it's done in writing, we can get to this, whether it's in writing or with witnesses or what, but she's got to look beyond that. But the fact of the matter is, even if she can't just take what Smith said and just run with it and say, that's it, Smith's putting a marker down. It frames things, first of all, but also it says, I intend to prove, and I am taking on the burden of proving that this was not Pence acting in his capacity as vice president, and that Trump was acting as a candidate.
So this raises a really interesting question as I'm thinking about it. What if it's like, if it's a question of fact, well, I guess I don't know. Is it a question of fact or law if he was acting in his capacity as the president of the Senate? You know what I'm saying? Like,
I get it.
To our listeners, the reason that this matters is that questions of fact are determined by a jury. Questions of law are determined by a judge. And so it's really weird because it seems like the Supreme Court immunity decision sort of creates like a paradox in some ways, because if there are certain things that a jury would need to find to even determine if something is an official act and therefore immune, but if it's immune, then it can't get there in the first place. So, it must be a question of law then. I guess she has to be able to just determine those things, even if, right?
Yeah. Or it's a mixed question or something along those lines. But this is where I wanted to I think the next part of our discussion has to go, which is, where do you go from here? The Supreme Court decision is very bizarre, unusual decision, definitely a first of its kind in more ways than one. But one thing it does, I'll just say this as a person who's a trial lawyer. I'm literally preparing for a criminal trial right now, federal criminal trial. That, when you are preparing for trial, whether you're a prosecutor or a defense attorney, you're trying to look ahead and determine what evidence am I going to be seeing at trial? Which witnesses are going to testify? What charges are there? What conduct's at issue? And there's an element to which this could all be a big, like shrug, like who knows going into this trial. And that's part of the reason why, of course, the judge is going to have to figure this out in advance. If she doesn't try to police on the front end and take a look and say, this can come in, this can't come in, et cetera, it could be almost impossible to get through a trial in this case. Because first of all, if let's say all of it's up in the air, well, then there's going to be constant objections that it's all official acts throughout the entire trial. The judge is going to have to figure that out through the course of the trial. And then let's just say some stuff comes in, some evidence comes in, and then later she's like, oh, this was an official act. Well, how you're going to have some limiting instruction to the jury, like ignore all this testimony you heard or evidence you saw. It would be an absolute mess. And so she's going to have to figure this out as best she can in the front end. You can imagine that Trump's team is going to try to appeal that directly to the Supreme Court, and that'll be quite a mess.
Which kind of gets to the timing here, which is, I mean, this ain't going anywhere before the election, obviously, but even after, it's still moot unless he loses the election.
I agree 100%. So as a practical matter, I expect Jack Smith. I mean, my prediction would be Jack Smith essentially says, okay, we're going to just file whatever evidence we're going to file, representations, we're going to make, put all kind of set forth all of our evidence in writing and proceed in that way. And, the defense is going to respond, and you can just decide it based on that, Judge. I don't think there was all this discussion of a mini trial. We've talked about that in the past. I thought that was, I would say, wishful thinking or fantastical thinking by legal analysts. I don't think that's going to happen. But even if it did, I just don't see the judge having all that occur before the election at this point. And like you said, Asha, I mean, whatever the judge decides, whether it's on papers, just on filings, or whether there's any witnesses like Pence who would testify, that's not going to really get concluded until, probably after the election. And then there's going to be an appeal, which means, the Supreme Court's going to end up taking this up, and that won't occur till 2025, well after, let's say, President Trump took office.
I think that's right. So, I mean, that would mean like a trial, though, earlier probably than like 2026, really, right? Because think about it, the election would have to happen. Trump loses. This all goes. Chutkan has to go through the whole thing, as you just said, litigate all of the issues, and the Trump team is going to challenge pretty much everything. They're going to challenge the tweets. They're not going to just only challenge the Mike Pence conduct. They're going to challenge a bunch of stuff, because they're going to say everything is in the outer perimeter. She has to then go through, decide on that, issue a ruling that's going to get appealed, and then, like you said, it has to make it to the Supreme Court. They have to take it, then they have to schedule the oral argument for that. I mean, we're really not realistically even looking at next year, I don't think.
Yeah, I mean, if it was, it would be very late in the year. I think realistically, let's just say Trump loses, and let's also say that he's realistic about the fact that this is going to get resolved before any other run for president, and so he's going to have to deal with it. If you were dealing with, put aside the fact that Trump may try to dictate the defense strategy as he did in New York. Okay, putting that to the side, you have a rash defendant is just like, what should I do? Criminal defense attorney. I mean, what I would say is I would want to have hearings. I'd want it to be public. I want to get all those witnesses in the witness stand. I'd like to cross-examine all of them and go get very granular and try to develop, try to question Mike Pence about what capacity he was acting and this and that. And then like you said, you'd have all this appeal, and then you'd come down, you get a Supreme Court decision that might split the baby in some way. In other words, some for Trump, some issues for Trump, some issues for Smith. And then even then you might pre-trial and during the trial continue, the defense would continue to raise this issue throughout the entire trial to just force the government to have to think about it, force the prosecutors to always have this in the back of their minds and muck up their case and so forth. I mean, I just think that this issue is going to infect the trial, because unless Supreme Court really resolves every issue on a second opinion, which I doubt, there's just continual factual development and things that are going to happen at trial that could potentially touch on this immunity issue. So, Asha, this was not the only development of the week. We also had Jack Smith appealing the dismissal of the Mar-a-Lago indictment by Judge Cannon. And I think it was interesting. I feel like the other, quote, big surprise to people who were watching this is that he didn't try to do anything or say anything to suggest that he wanted to get Judge Cannon replaced. And I have to say that didn't surprise me at all. I think we've been discussing this in the podcast. It's very, very difficult to get a judge off a case.
Yes, but isn't the idea that if she gets overruled in this instance, then there might be a stronger ground to do that?
I don't think so. And here's why. I mean, first of all,
Okay.
Justice Thomas, I think, gave her some cover here because you have a justice in the Supreme Court making this argument. Now he did it just sort of, I would say, use Latin words, sua sponte.
Yeah, he was giving her the answer key. He was giving her the answer key. Let's be honest.
It really didn't have a lot to do with the immunity decision. I think it's like, hey, by the way, here's my views on Jack Smith and so forth, right?
Yeah. It was Eileen Cannon, if you're listening.
Yeah, there you go. Great allusion to Russia, if you're listening. But yeah, I think so. I think she's just could take the view. Look, I have the same view of the law that a Supreme Court justice has here. I viewed it this way, and I made this decision. And really, it buys Trump a bunch of time. I don't think there's any chance. I don't want to say there's any. I should not predict that. It's unlikely that Trump's going to win this one. He's going to lose in the 11th Circuit. He's probably going to lose in the Supreme Court, despite having the votes. I don't know, but we'll see. It would require not only contradicting a bunch of prior rulings, but also invalidating special counsels like the one who investigated Pence, the one who's been working to prosecute Hunter Biden and so forth. But putting that to the side, it's still going to then come back to Judge Cannon. And then, Smith can continue to wait for her to make more mistakes. I'll just say, as somebody who has been in front of my share of judges who I've had sharp criticism of, that I've kept to myself for my client's benefit, it's very, very difficult in any kind of case to get a judge off when they don't want to get off the case in a federal court.
So let's talk about the appeal. So we, in a previous podcast, we talked a little bit about the appointments clause issue, and the idea that principal officers under the Constitution have to be appointed by the president, and inferior officers, you can have, I guess, subordinate officers appoint them, and in this case, the Attorney General. And so, the legal question has often turned on, is a special counsel a principal officer, an inferior officer? Because if he's the former, then the Attorney General wouldn't have the constitutional authority to appoint him. Now, Judge Cannon's ruling did not get to that question. She made her decision on statutory grounds. She looked at the statutes which operationalize the constitutional authority, if it exists, that then vest authority in the Attorney General to appoint a special counsel and to do it in these different ways. And she basically said that these 4 statutes that she looked at, that none of them vested authority in the Attorney General. And then she said that as a result, the special counsel is not eligible, to receive funding to basically operate, I guess. And so Jack Smith, he focuses on that statutory analysis as well. Now, to be clear, what she did, and we can talk about this, she was basically invalidating US v. Nixon. So US v. Nixon, which was challenging the special counsel or special prosecutor in that case's issuance of a subpoena for the Watergate tapes, has a part which looks at the statutory authority of the special prosecutor. And basically, says that the prosecutor is authorized, and then kind of moves on to the legal issue about the subpoena. And what Judge Cannon says in her ruling is, well, that was all dicta and it's not binding. Because look, ordinarily a Supreme Court decision would be binding on her. And so let's talk a little bit about the distinction between dicta and holding, because your average listener doesn't know that.
Sure. In any court decision, there's going to be there's a lot of words that you've probably had seen links to them online. You look and you're like, oh my God, there's a lot of legal jargon, a lot of legal discussion. But there's a generally the substance. When you look at the Supreme Court decision or a lower court decision, there's going to be a part of it that ultimately controls whatever and what the result is. So there'll be portions of, let's say, when we talked about the U.S. versus Trump decision on our last segment here earlier, we were talking about there are certain portions that said whether, for example, a president had immunity for official acts. Why are those portions of that decision important? Well, those are essentially determine the outcome of the case. You think of it that way. But not everything the Supreme Court says in an opinion determines the outcome of the case or goes to all those ultimate questions. Sometimes the Supreme Court has background discussion. Sometimes they'll have an aside. We just talked a moment ago about Justice Thomas in a dissent. That is a dissent, but unless, even if he was writing the majority opinion, if he didn't have 5 justices join as to that, it's essentially just a side discussion. It's still relevant for people to look at. It's basically something that you're citing that could be persuasive, the same way that you might read an article in a law journal and find it persuasive, but it doesn't control the outcome of that case. And so it's not really part of what's called the holding. I don't know. Is that a good way to explain it?
Yeah. I mean, when I'm teaching my national security law class, I teach typically to non-law students, I say that dicta is not necessary to the reasoning of the holding of the opinion. So if it's not essential, and in other words, if you could take that piece out and the logic and reasoning could still stand, then it's really dicta. And there are cases where it's where people will cite dicta as sort of the holding of a case, and that's very bad form to do as a lawyer, though it is done often.
Right. So I was going to say a couple of things. First, I think your definition is better than mine. I like it because, well, I give credit where credit's due. Partly because what it's suggesting is, I was really focused on what the conclusion was, but you're right that there's going to be elements. Sometimes you have to have a bunch of building blocks along the way, and I think it's helpful and correct to think of that as part of the holding as well. So I think that's a better way of thinking of it. But you're right. I mean, what that was going to be where I was going to go with this, Asha, as well, is that the line between dicta and holding is not precise. It's a distinction that is ignored by lawyers all the time. It's also something trotted out occasionally when you're in a bad position, when it's like, oh no, the Supreme Court case goes against me. And you're like, oh, that's just dicta. And that's really, I think, what Justice, maybe if Trump wins, but Judge Cannon is doing here is essentially saying, I'm ignoring this part of a Supreme Court decision that I don't like. And I'm just calling it dicta. I feel like it's a label that gets misused often.
Right. And so the way that Jack Smith starts out his appeal, he focuses on this aspect of Judge Cannon's ruling, is he says it was absolutely essential to the holding of the case to establish that the special prosecutor there was properly appointed under the statute, or there was authority to appoint him under the statute. In other words, if that special prosecutor didn't have that authority, then there would be no reason to get to the other issue about the subpoena and its validity. So he is making that building block argument and saying that basically canon is just wrong. This was not dicta. This was essential to the outcome and reasoning and outcome of that case.
Yeah, it's a very clever argument by Smith because the Supreme Court's going to be loath to want to overturn United States versus Nixon. It's a landmark decision that has been cited many, many times. And he's sort of putting it squarely on the court. Like, this is not just some standalone question, but it's actually a question in which you've already ruled, and this decision essentially goes against it. It's also, if he's right, and if the 11th Circuit is looking at this is the Court of Appeals in between Judge Cannon and the Supreme Court. They essentially have to side with him on this as well.
Right, because if he's right, then the Supreme Court of prior Supreme Court precedent is controlling. So they don't. This isn't some unanswered question of law.
Correct. And a Supreme Court decision has to be followed by the Court of Appeals and by Judge Cannon.
Right. So, from there he goes into, because she also then goes into these statutes and she kind of nitpicks. She does this weird statutory interpretation, which if you want to go through some of it, we can. Looking at the tenses of the words and, to argue that none of these statutes authorize the Attorney General to appoint him. And he basically goes through all of these different statutory authorities and says, yes, they do. And then he gets to your point, Renato, where he says, and by the by, there is a very long history of court cases assuming that, or establishing that Nixon was correct and using that to uphold the authority of special prosecutors, later independent counsels, later, special counsels.
Yeah, and Asha, I think that brings us to another important issue, which is that Justice Thomas's dissent was actually focused on the constitutional issue, which we had discussed previously when we were discussing this, essentially whether or not this is whether the special counsel is an inferior officer for purposes of the Appointments Clause of the Constitution. So one thing I wonder is, let's just say that this ultimately goes up to the Supreme Court, and this has only been decided on the statutory issue. It'll be interesting to see what happens if, for example, Justice Thomas and others in the Supreme Court want to decide this on the constitutional issue. I suppose they can try to expand the question presented to try to present that question as well. But it's interesting, right? She essentially didn't go down the exact road. She kind of followed the argument in a way, but she went down a different path to get there than Thomas did, a path that implicates some of these prior decisions.
Yes, it is interesting. I think, it would be a little bit crazy for them to follow her reasoning that Nixon itself didn't do this, because that would be a little weird. So there could be two things. The Supreme Court can reframe the question presented, or they can answer whatever question they want, really. But okay, so technically it's a canon of judicial it's a canon
interpretation
of judicial interpretation that you don't decide a constitutional issue if you can decide it on statutory grounds. In other words, it's called constitutional avoidance. You try to avoid making big constitutional things. So, in theory, maybe, that's what she was doing. Though they could do whatever on the statutory point. Like, let's say they do, the Supreme Court says, no, I guess they couldn't do that. I'm just wondering if there's a way that then she gets a second bite at the apple and gets to say, okay, well, then I'm just going to make the constitutional argument now, and this is unconstitutional.
They could. That's possible. That would just blow more time off the clock.
That's what I'm saying. I wonder if that was her play, is let me do this piecemeal.
That's possible. I was also trying to think to myself, like, could the Supreme Court then just say, well, the constitutional issue isn't before us, and sort of signal to her
Right. Yeah.
that they're not deciding that, and they just view that as not before them yet, and blah blah blah. So yeah, I think that's possible. It's also possible that they'll just reach and grab that issue. I mean, I think the Trump team did not put forward all of the questions and issues that ultimately got decided by US v. Trump. And the Supreme Court, I think, expanded its view of what was before them in order to reach the result that it did. So it's entirely plausible as well, since that there's already one vote for this constitutional view, that maybe there might be four others, and they just reach out and grab it. So either way, it could essentially achieve the same result, because Trump is in his 80s, right? Pretty sure he's late 70s. If this kind of has another run back up to the Supreme Court, and then goes back down to her, and has another run up to the Supreme Court again, and goes back down to her, you could imagine that this case could drag on for years to come.
Yeah. I don't think it's out of the realm of possibility that they would want to reach out and grab it, because if you think about their theory of the presidency as articulated in the immunity case, that would seem to suggest that they're not big fans of an entity that comes out of the executive branch being able to turn around and prosecute the head of the executive branch itself.
Yeah, they definitely,
like, it kind of it doesn't fit with this whole unitary executive theory.
Yeah, I think this is a Supreme Court that's not afraid to overrule precedent. All right, I think we've seen that already, and so yeah, I think anything is on the table. We can't predict exactly how this will go. I think it'll be interesting to see what happens if Trump doesn't win. If he won, a lot of issues would effectively be decided by the fact that he's the president of the United States, and he's just going to direct this case to end. But if that doesn't happen, you can imagine the Supreme Court going in a very different direction in terms of, future investigations coming of executive branch officials. I mean, I don't know what it would look like without some sort of, whether it's independent counsel or special counsel, given how congressional investigations can be stymied. You'd end up effectively entrusting the president to investigate herself or himself, which is not, I would say, a pathway to avoiding corruption by the president of the United States.
Yeah, the whole idea of the special counsel, the independent counsel before that, and the independent prosecutor before that, is to create a buffer that allows for the independent administration of justice. To eliminate that buffer is basically to say that the president is above the law. And that's what they've already said in the immunity case. So that's why I'm saying that it would just be like peas in a pod for them to go down that road.
Yeah, it's congruent with the
congruent. Thank you.
It's congruent with the president essentially having the power to do all sorts of things, like abuse the Justice Department, the authority to prosecute in the Justice Department, and all sorts of other things, in order to achieve corrupt ends.
So Renato, before we go, I'm having friends over for dinner tonight, and I was thinking before we were recording the podcast, how do you feel about entertaining people? Well, I feel like that's the thing that some people like and some people don't like, and I'm curious what you think.
My wife loves it. Like, she just gets such a kick out of entertaining. It's a big thing. She loves inviting people over, and she makes charcuterie boards and does the whole thing. And she's always trying to come up with excuses to invite all sorts of people over and have big events. I'm not as enthusiastic about it. I'd almost rather go out someplace else. I work from home a lot of times, not all the time. And, I don't know. And it just feels like a lot of work to have people over, and it's much more enjoyable to just be out somewhere doing something. but I totally get why it's a lot of fun for her. I think the joy is showing off her home and making special dishes for everybody.
Yeah, I enjoy it too. I like it in smaller groups because, I like to cook and I like to make a few different things. And it's just a lot easier when you're not cooking for like a huge number of people. And also, my house is pretty small. Like, I think that's the one thing that that dissuades me a little bit because, it's this, um, pretty standard, I think, like New England. What style is my house? I think it's a colonial. But it's not. It's got good flow, given that it was built in 1927. But it's not the kind of house where you can like have a big massive Christmas party or something like that.
Yeah, we do. We have a larger home because we're in the suburbs in Illinois, and we'll do like fundraisers or events like that. But like for the holidays, I don't know about you, but I like just having family over. Like I feel like having like everybody we know over for the holidays can be a bit much. That's the way
Yeah,
I look at it.
yeah. I fortunately don't have that problem. My sister has the McMansion in Texas.
Oh my god.
Yeah, so she's that's ground zero for when we get together as a family because she just has a ton of room. She has a swimming pool. She has a media room. She's
Wow.
got I know. So, and, unfortunately, I mean, I love going there and it is fun and my kids love it, but over the last few years it does force me to go to Texas, which I don't love. I
Yeah.
mean, no offense to the Texans out there. I know that you guys are fighting the good fight, but it's stressful.
Yeah. A lot of guns and not a lot of rights for women and others.